is a big one. MP Barrett is going to bring up all of this charges almost about contempt of committees, and he's got a lot of big points. We're going to see what's going on. Watch this.
It's a long one, and I always get it wrong, so I'm going to cheat a bit here. Leeds, Grenville, Thousand Islands, and Rideau Lakes. Thank you.
Thank you very much, Mr. Speaker, and thank my colleague for his assist. Make sure that that's recorded for posterity. I'm rising today on a question of privilege concerning the Liberal government's disrespect of an order of the Standing Committee on Finance requiring the production of records related to the Prime Minister's $500 million WE scandal. At its July 7th meeting, the Finance Committee adopted the following motion, quote, that pursuant to Standing Order 108-1A, the committee order that any contracts concluded with We Charity and Me to We, all briefing notes, memos, and emails, including the contribution agreement between the government and the organization, from senior officials prepared for or sent to any minister regarding the design and creation of the Canada Student Service Grant, as well as any written correspondence and records of other correspondence with We Charity and Me to We from March 2020 to be provided to the committee no later than August 8, 2020. That matters of cabinet confidence and national security be excluded from the request, and that any redactions necessary, including to protect the privacy of Canadian citizens and permanent residents whose names and personal information may be included in the documents, as well as public servants who have been providing assistance on this matter, be made by the Office of the Law Clerk and Parliamentary Counsel of the House of Commons, end quote. On or about August 8th, the government provided the Finance Committee's clerk with about 5,600 pages of materials. These documents were subsequently released to committee members on August the 18th, mere minutes before the prorogation of Parliament. It's important to understand that these pages often included several copies of the same emails, and worse, many of the pages featured blacked out, redacted, obscured, and hidden content. It's those redactions which trouble me and which should trouble every member of Parliament. To quote Mr. Speaker Milliken from his highly publicized Afghan detainee documents ruling on April 27, 2010, this is on page 2042 of the debates. Before us are issues that question the very foundations upon which our parliamentary system is built. In a system of responsible government, the fundamental right of the House of Commons to hold the government to account for its actions is an indisputable privilege and, in fact, an obligation. The Finance Committee exercised its privilege and obligation to get to the bottom of this extraordinarily troubling WE scandal when the Prime Minister handed his friends $543.33 million in a contribution agreement to run a paid volunteer scheme, instead of trusting Canada's hard-working public servants to administer the CSSG. In doing so, the order it passed, and which I quoted, allowed for cabinet confidences and national security content to be excluded, with all other vetting was to be done by the Office of the Law Clerk and Parliamentary Counsel. Of course, a contract to a children's charity for a youth volunteering program would not involve national security, Mr. Speaker, but it is simply a standard form of a motion generally being used at committees lately. The government, however, contravened the committee's order as explained in the Law Clerk's own August 18th letter to the Finance Committee. I quote, "The letters accompanying the documents for each department stated that redactions had been made to protect cabinet confidences in accordance with the motion adopted at FINA. In addition, the letters and documents indicate that the departments had also made redactions to protect personal information in accordance with the Privacy Act. To protect third-party information and information on the vulnerability of their computer or communication systems or methods employed to protect their systems, these latter grounds for exemption from disclosure are contained in the Access to Information Act. Upon reception of the documents on August 9, 2020, you provided them to my office so that we could make the necessary redactions to protect the privacy of Canadian citizens and permanent residents, as well as public services as contemplated by the production order. However, as mentioned above, the documents had already been redacted by the departments to protect personal information and on other grounds." Close quote. Here comes the kicker, Mr. Speaker. Quote, as my office has not been given the opportunity to see the unredacted documents, we are not able to confirm whether those redactions are consistent with the order of committee, end quote. So further down the page, Mr. Dufresne adds, quote, as mentioned above, the department made certain redactions to the documents on grounds that were not contemplated in the order of the committee, end quote. A moment ago, I referred to the Finance Committee using a familiar form of motion. I should pause here to note that the entire pattern of document redactions is also familiar. On February 26th, the Health Committee adopted a document production order seeking records concerning the Liberal government's preparations for the current pandemic. And in response, the government provided significantly censored documents covering up key details about the Liberals' failures to prepare Canada adequately against COVID-19. That episode required Mr. Dufresne to write a similar letter to the clerk of the Health Committee, noting that government's open defiance of a parliamentary committee exercising its constitutional rights. For a government which preaches transparency and, quote, openness by default, close quote, their track record of blacking out inconvenient facts speaks louder. But one significant evolution since the Health Committee's experience is that here the government tried to deflect responsibility elsewhere for the redactions. According to an August 27th article in CBC News entitled, Commons Law Clerk Says Governments Went Too Far in Redacting We Charity Documents, I'll quote, last week a spokesperson for the Prime Minister's office told CBC News that the redactions were done by the parliamentary law clerk who was following the committee's direction to remove documents covered by cabinet confidentiality and personal information about Canadian citizens, end quote. The Prime Minister's office was trying to deny its complicity in the cover-up of these documents. In fact, Mr. Speaker, this seems to have been a talking point circulated amongst Liberals. On the evening of August 19th, I was part of a panel discussion on CBC's Power and Politics, along with the Parliamentary Secretary to the Minister of Justice. He repeated the Prime Minister's Office's alternative facts and told viewers that night, quote, the motion included a proviso that redactions should be done as necessary to protect certain interests, including privacy interests, etc., and those should be done by House administration, including the Office of the Law Clerk. That's exactly what happened in this case. The motion was followed to the letter. Redactions were done not by the government and not by political staff, but by House of Commons objective officials, end quote. The Prime Minister's office's denials have been exposed as bald-faced lies in the law clerk's letter. Those denials were also given voice by the parliamentary secretary, likely having been unwittingly briefed and scripted by the PMO to believe that they were true. It's my respectful submission, Mr. Speaker, that two separate grounds for a prima facie contempt of Parliament are made out in these facts. Firstly, as the law clerk and parliamentary counsel informed the committee's clerk on August 18th, the government disrespected a lawful order of a committee of the House of Commons to produce documents. This is, for reasons I will argue, an appropriate case to come directly before this House. Second, the Prime Minister's office and the parliamentary secretary, in attempting to deflect criticism from the government's redactions of those documents in disobedience of a committee's order, made misrepresentations about a work of a table officer of this House and risked damaging his reputation in the process. Allow me to offer you some of the applicable precedents and procedural background to these issues. As to the first ground, the breach of a committee order, the law clerk's own letter helpfully offers a succinct explanation of the situation. Quote, we note that the House's and its committee's power to order the production of records is absolute and unfettered, as it constitutes a constitutional parliamentary privilege that supersedes statutory obligations, such as the exemption found in the Access to Information Act. The House and its committees are the appropriate authority to determine whether any reason for withholding the documents should be accepted or not. One such measure is the committee's decision to have my office make the necessary redactions to protect personal information and the public servants providing assistance in this matter, end quote. Page 137 of the House of Commons Procedure and Practice, 3rd edition, explains the source of this authority. By virtue of the preamble and Section 18 of the Constitution Act of 1867, Parliament has the ability to institute its own inquiries, to require the attendance of witnesses, and to order the production of documents, rights which are fundamental to its proper functioning. These rights are as old as Parliament itself. Bosch and Gagnon add further down on that same page, I quote, "For the purpose of an inquiry, the committee may send for any papers that are relevant to its order of reference." This right to order the production of documents is unlimited at pages 984 to 986, and Bosch and Gagnon elaborate. And I'll quote, "Public servants and ministers may sometimes invoke their obligations under certain legislation to justify their position. Companies may be reluctant to release papers which could jeopardize their industrial security or infringe upon their legal obligations, particularly with regard to the protection of personal information. Others have cited solicitor-client privilege in refusing to allow access to legal papers or notices. These types of situations have absolutely no bearing on the power of committees to order the production of papers and records. No statute or practice diminishes the fullness of that power rooted in House privileges unless there is an explicit legal provision to that effect, or unless the House adopts a specific resolution limiting the power. The House has never set a limit on its powers to order the production of papers and records," end quote. Tension between government and Parliament on the interaction between the Access to Information Act and the Privacy Act on the one hand, the document production orders on the other, is as old as the laws themselves. For example, the first report of the former Standing Committee on Privileges and Elections from the 3rd session of the 34th Parliament states at page 98 of the journals for May 29, 1991, and some of these books were not available from the Library of Parliament due to COVID limitations, so I'm drawing from digital texts. Quote, "After careful consideration and consultation, the committee has concluded there is nothing in the Privacy Act to prevent the House of Commons from issuing an order for the production of unexpurgated versions of the two reports. The House, in our opinion, has the absolute power to issue an order requiring the Solicitor General to provide the two reports in their entirety, end quote. Disregarding a committee order is a very serious matter. Now, page 239 of Parliamentary Privilege in Canada, 2nd edition, explains this, Mr. Speaker. Disobedience to rules or orders represents an affront to the dignity of the House, and accordingly, the House could take action, not simply for satisfaction, but to ensure that the House of Commons is held in the respect necessary for its authority to be vindicated. Without proper respect, the House of Commons could not function. Thus, disobedience may well be considered contempt. In substituting its own judgment for the Finance Committee's or the law clerk's, the government has overstepped its authority and flouted the will of the Finance Committee. Sir John Bournois, in his first edition of Parliamentary Procedure and Practice in the Dominion of Canada, wrote at page 281, quote, "It must be remembered that under all circumstances it is for the House to consider whether the reasons given for refusing the information are sufficient. The right of Parliament to obtain every possible information on public question is undoubted, and the circumstances must be exceptional and the reasons very cogent, when it cannot be at once laid before the House," end quote. In the Afghan documents ruling, the chair articulated at page 2044 an approach to raising those, quote, reasons very cogent, quote, namely to make the case through the persuasion of debate and the offering of amendments to the motion under debate. In the end, the government does not have the final say, for as Speaker Milliken put it, quote, "The House debated the matter and voted to adopt an order for the production of documents despite the request of the government," end quote. In usurping the role assigned to the law clerk, the Liberal government's evasion of accountability represents a grave affront to the dignity and authority of the House of Commons. Now, page 138 of Bosch and Gagnon speaks to the present situation.
Much time as he needs.
If such an order is ignored, the committee has no means to enforce the order on its own. It may report the matter to the House and recommend that appropriate action be taken. It is then a decision of the House whether or not to issue an order for the production of papers. Obviously, the committee was unable to report its situation directly to the House because the Prime Minister shut down Parliament through prorogation, quite literally within minutes of the documents becoming available. In fact, Mr. Speaker, it has become perfectly plain for all to see that the motivation for prorogation was to shut down committee investigations, getting a little too close to the Prime Minister for his own comfort. If the speech from the throne was about presenting a refreshing agenda reflecting the COVID pandemic, the Prime Minister could have simply prorogued Parliament the night before last, or yesterday morning for that matter. What he didn't need to do was to shut down Parliament on the 18th of August. The only thing that accomplished was to kill committee investigations cold in their tracks. Now, this brings me to pages 152 and 153 of Bosch and Gagnon, which I want to address directly. Quote, "Speakers have consistently ruled that, except in the most extreme situations, they will hear questions of privilege arising from committee proceedings only upon presentation of a report from the committee which deals directly with the matter," end quote. The present situation, Mr. Speaker, is, I would respectfully submit, one of those extreme cases where the Speaker's direct intervention is warranted. This is not a matter on which we can just pick up tomorrow where we left off. Page 977 of Bosch and Gagnon explains, quote, "Certain specific conditions must be met to continue with a study begun during a previous session of Parliament. Finally, committees must be constituted, that is, they must be assigned members and a chair must be chosen," end quote. The Finance Committee has no members, it has no chair. In fact, Mr. Speaker, if the Liberals were being particularly cynical, they could exploit parliamentary tactics to keep our committees from considering substantive business until November. On December 4th, 1992, the House considered a question of privilege concerning the intimidation of a subcommittee witness. In making his argument, then Liberal Deputy House Leader Don Boudria said at page 14,630 of the debates, quote, "I wish to bring to your attention, in the unlikely event that you would be tempted to rule that this matter should be dealt with at committee, that in fact the committees are in the process of winding down for the Christmas period. The evidence was brought before a subcommittee, which has terminated its proceedings for the next few months. Therefore, the evidence of this could only be heard before committee in a number of months from now at the earliest, if at all, in the event of a prorogation of Parliament later," end quote. For his part, Mr. Speaker Fraser argued at page 14,631, ruling, quote, "Some mention has been made that this matter arose in committee, and honourable members will have heard me say many times that usually matters should be put back to committees. My own feeling is that under the circumstances which have been explained to me, that is not the convenient or appropriate thing to do at this time." Mr. Speaker, your most recent privilege ruling concerned a complaint about something which had previously arisen in Committee of the Whole, and Bosch and Gagnon explain on page 919 its relevance to the present case. Once that committee has completed its business, it ceases to exist. In your ruling on July 22, 2020, at page 2701 of the debates, you said, quote, "I accept that the particular circumstances of this situation, notably the challenge surrounding the committee of the whole format, do make it appropriate to bring the matter to the Speaker," end quote. We are, I would argue, in substantively the same position today with standing committees such as the Finance Committee. They were terminated with prorogation, and they have not yet been reconstituted and may not be for some time. I respectfully submit that you ought to extend, by analogy, your July ruling, not to mention, Mr. Speaker, Fraser's 1992 ruling, to the present circumstances of unconstituted standing committees. Prorogation denied the committee the opportunity to meet and to report this abuse by the government to this House. The time necessary to reconstitute committees and the delays which could be attempted compounds this problem. The House must have a means to address behavior contemptuous of committees. Having made out the grounds for finding a prima facie contempt, I want to speak briefly on the remedy. When members rise on questions of privilege, the chair always hears that they are prepared to move an appropriate motion. I, too, am prepared to do so. However, I should quote Mr. Speaker Milliken, who asked rhetorically in the 2010 ruling I've cited at page 2044, quote, "The authorities I have cited are unanimous in the view of the House's privileges to ask for the production of papers," and many go on to explain that accommodations are made between those seeking information and those in possession of it to ensure that arrangements are made in the best interests of the public they both serve. It is possible to put in place a mechanism by which these documents could be made available to the House without compromising the security and confidentiality of the information they contain. In other words, is it possible for the two sides working together in the best interest of the Canadians they serve to devise a means where both their concerns are met? Surely that is not too much to hope for." End quote. This notion of a prima facie ruling forcing an opportunity to reach a negotiated settlement before addressing the matter through a motion and vote was echoed by Speaker Levac of the Legislative Assembly of Ontario on September 13, 2012, at page 5 of the Votes and Proceedings. That's a ruling which should ring bells for some Liberals across the way, specifically for staffers in the Prime Minister's office. It concerned the Dalton McGuinty government's defiance of a document production order related to the gas plant scandal. Many of the folks at the heart of the Ontario Liberal operation later picked up and headed down the 401 to Ottawa, some with outrageously high expense claims, I should add. And they brought their political playbook to the nation's capital. One of them who didn't make it to Ottawa, though, was Dalton McGuinty's chief of staff. He was instead sentenced to imprisonment for his role in destroying gas plant scandal records. So it should go without saying that opposition members of Parliament are anxious to lay hands on the full records of the sweetheart deal between the Prime Minister's friends at WE and the Canadian taxpayers. Through you, Mr. Speaker, can I just say to the government that Conservatives are prepared to be constructive and reasonable, if it means getting expeditious access to the documents in question. Perhaps in the time you're deliberating on these issues, we may be able to reach an adequate compromise. To throw out an idea here, I'd note that among the ranks of the official opposition are several Privy Councillors. One or more of them, on the strengths of their Privy Council oaths, could view the documents to be able to provide assurances to other MPs that the government's grounds for redactions are legitimately claimed. Now, I recognize that solution may not work well for the members of the other two opposition parties. Perhaps an alternative would be for the government to simply allow the House Law Clerk and his team of lawyers a chance to view the original documents so that they can provide MPs with these assurances. I'd note in passing that the Law Clerk's own special advisor and counsel previously served as Chief of Staff to the Minister of Women and Gender Equity and Rural Economic Development, so I couldn't imagine the Liberals having a serious objection to this course of action. Nonetheless, my point, Mr. Speaker, is that there are solutions staring us right in the face. If only the Liberal government would engage us on them. However, if discussions cannot reach an expeditious compromise, I am fully prepared to put a solution forward by way of a motion for the House to decide. Now, next, Mr. Speaker, I'd like to turn the second ground for a prima facie contempt finding, the Prime Minister's Office's lies about the law clerk redacting the documents. Now, Bosch and Gagnon explain this contempt at page 81. Quote, "There are, however, other affronts against the dignity and authority of Parliament which may not fall within one of the specifically defined privileges. Thus, the House also claims the right to punish, as a contempt, any action which, though not a breach of a specific privilege, tends to obstruct or impede the House in the performance of its functions, obstructs or impedes any member or officer of the House in the discharge of their duties, or is an offence against the authority or dignity of the House, such as disobedience of its legitimate commands, or libels upon itself, its members, or its officers." End quote. It's worth noting here, Mr. Speaker, that the corresponding entry in Parliamentary Practice, New Zealand 4th edition, at page 763 clarifies that the reference to libels extends to slanders. But in any event, Bosch and Gagnon at page 81 elaborate upon the scope of contempt of Parliament. Quote, "The House of Commons enjoys very wide latitude in maintaining its dignity and authority through the exercise of its contempt power. In other words, the House may consider any misconduct to be contempt and may deal with it accordingly. Throughout the Commonwealth, most procedural authorities hold that contempts, as opposed to privileges, cannot be enumerated or categorized." End quote. To be clear, Mr. Dufresne is, of course, a table officer of this House. Citation 219 of Beauchen's Parliamentary Rules and Forms, 6th edition, reminds us that, quote, "The officers in the service of the House of Commons are the Clerk of the House, the Sergeant-at-Arms, the Law Clerk and Parliamentary Counsel, the Deputy Clerk, and the Clerk's Assistant." End quote. The Prime Minister's Office, in its effort to spin its way out of a scandal which has enveloped the whole government and claimed the career of a finance minister, lied about the work of Mr. Dufresne, attempting to lay blame at his feet. What's more is that the Prime Minister's staff enlisted a member of this House, the member for Parkdale High Park, to go on television to spread their spin about the law clerk. Magnon at page 250 writes, quote, "As in the case of a court of law, the House of Commons is entitled to the utmost respect. Thus, when someone publishes libelous reflections on the House, they will be treated as a contempt of this House." End quote. Indeed, in a case concerning the defamation of a table officer, Mr. Speaker Tusa of the Legislative Assembly of Saskatchewan on June 24th, 1987, at page 79 of the journals, found a prima facie case of privilege about remarks which, quote, "may have harmed the credibility of the Legislative Council and law clerk," end quote. In that case, the Legislative Assembly subsequently adopted a motion, quote, "that this House accept the apology of the Minister of Justice with respect to his public remarks attacking the credibility of the Legislative Council and law clerk, and confirms that those remarks constituted a breach of privilege of this Assembly." End quote. Madam Speaker Sauvé articulated a view on October 29, 1980 at page 4213 of the Debates on an Appropriate Threshold when Falsehoods are Deployed. Quote, "Members will appreciate that the expression false is subject to but one interpretation in the House of Commons debates. That is, pejorative, and it is considered unparliamentary when referring to another honourable member. While the word has less sinister meanings in the context of contempt, it seems to me that to amount to contempt, representations or statements about our proceedings or of the participation of members should not only be erroneous or incorrect, but rather should be purposely untrue and improper and import a ring of deceit. To be false in the context of contempt, an interpretation of our proceedings must be an obviously, purposely distorted one. My role, therefore, is to interpret the extracts of the document in question, not in terms of their substance, but to find whether, on their face, they represent such a distorted interpretation of the events or remarks in our proceedings that they obviously attract the characterization of false." End quote. The Prime Minister's Office quite clearly knew who was responsible for redacting the documents provided by the government to the Finance Committee when they were spinning journalists and putting out the Justice Minister's parlsec on TV panels. We're not talking about the woman or man on the street in North Bay, Mr. Speaker, who might be following our proceedings from afar through the news. Instead, we're talking about a central player in the scandal implicating an esteemed officer, a table officer of this House, in a distorted interpretation of events purposely untrue and bearing a heavy ring of deceit. As Saskatchewan's Mr. Speaker Tusa said on May 23, 1989, at page 94 of the Journals, quote, "It is the duty of the House to protect its officers," end quote. And that goes to the essence of my question of privilege. Members of Parliament have many things said about us in the course of our work. But we also have many platforms, including the most awesome of them all, the floor of the House of Commons, to respond and defend ourselves. Our table officers, who provide us with such solid support and service, well, they, on the other hand, have no such outlet, and if they tried, could risk compromising their neutrality. That's why it's incumbent upon us, incumbent on this House, to protect our clerks at the table. That's why I'm asking you to find a prima facie contempt in respect of the Prime Minister's office and the Parliamentary Secretary's defamation about the role played by the law clerk in blocking government transparency and breaching a committee's order. Mr. Speaker, we must protect the hardworking staff of the House from being exploited. In this case, exploited for political gain, when there is a lie at the heart of such exploitation. If you find a prima facie contempt, I am prepared to move an appropriate motion. Thank you, Mr. Speaker.
I want to thank the honourable member for his submission, and we'll take it under advice.
Well, he laid a lot out for that. That's a lot to chew on. Leave your comments, of course. Do you think that this is going to go forward, or they're going to just sweep this one under the rug? Here's some other big issues that were brought up by the other MPs. Check it out.
Concern with the passing of the national security legislation in Hong Kong. It is their belief that the passing of this law is in gross violation of the Sino-British Joint Declaration and the One Country, Two System framework. The petition calls upon the government to impose appropriate sanctions under the Justice for Victims of Corrupt Foreign Officials Act. Thank you, Mr. Speaker.
Presenting petitions, the honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. It's a pleasure to be back. I'm presenting two petitions today. The first is in support of Bill S-204, which was put forward in the Senate by Senator Salma Atulajan. The bill would make it a criminal offence for a Canadian to go abroad to receive an organ for which there has not been consent, and also create a provision to make someone inadmissible to Canada if they had been involved in organ harvesting or trafficking. This is an important human rights bill. Efforts have been made to pass similar versions of this bill in this and the other place for over 10 years. The second petition speaks to the government's priorities with respect to health care. Back in January and February, when they could have been focusing on improving seniors' care, preparing for a response to pandemic, the government's focus was instead on removing vital safeguards associated with the government's euthanasia regime. Petitioners in this particular petition raised concern about the government's plans previously in Bill C-7 to eliminate a 10-day reflection period and also reduce the number of witnesses required. Petitioners believe that these were important safeguards that need to be in place, and question the government's priorities with respect to removing safeguards when there are so many other vital health care issues that we should be focused on. Thank you.
Presenting petitions, the honourable member for Vancouver East. You're on mute. Remove your mute.
Sorry, is this working now?
Perfect.
Thank you very much, Mr. Speaker. I have two petitions that I would like to table today. The first is signed by over 2,600 Canadians calling on the government to extend paid maternity leave for a minimum of 3 months for mothers in Canada during the pandemic, and that many of them are not receiving adequate health care due to the redirection of these health resources as a result of COVID-19. As well, many are not able to get affordable quality childcare at this time. So as such, the petitioners noted that COVID-19 has significantly impacted their physical and mental health, and they're calling on the government to allow mothers who are currently on 12 months maternity leave the option of switching into 18 months maternity leave. The second petition, Mr. Speaker, I have has a signature of over 6,000 people calling for action from the government. And these are particularly related to people who are struggling with family separation because of their delay in spousal sponsorship applications. People are desperate to reunite with their loved ones, yet the immigration process for spousal sponsorship has grind to a halt. So they're calling on the government to create a special temporary resident visa for outland applicants with a reasonable eligible criteria and conditions, and to allow for spouses and their children from visa-required countries to easily apply for the STRV online, and to issue and delivering multi-entry STRV electronically and expediently. We need to ensure that the capacity to process applications are increased and to address the lengthy delays that exist, and prompt action is required, Mr. Speaker.
The honourable member for Courtenay Alberni.
Thank you, Mr. Speaker. Mr. Speaker, I'm honoured to table a petition on behalf of residents from Cumberland and Courtenay in my riding. They're calling on the government to declare the current opioid overdose and fentanyl poisoning crisis a national public health emergency under the Emergencies Act in order so that the government can manage and resource it with the aim to reduce and eliminate preventable deaths from poison fentanyl. Mr. Speaker, we've lost over 147 residents in British Columbia. Just in August alone, the government hasn't declared it a public health emergency, despite the fact that over 15,000 Canadians have died since 2016. They want the government to reform the current drug policy, to decriminalize personal possession. And lastly, Mr. Speaker, they want the government to create with urgency and immediacy a system to provide safe, unadulterated access to substances so that people who use substances experimentally, recreationally, or chronically are not at imminent risk of overdose due to a contaminated source. And Mr. Speaker, these petitioners are mothers and fathers and brothers and sisters and cousins of people that have died and lost loved ones. The government needs to take action.
Presenting petitions, the honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. It's an honour to rise today on the traditional territory of the Algonquin peoples to present the following petition. It relates to an aspect of the climate crisis and calls on the government to deal with how we send our money to developing countries and how that money should be allocated. The petitioners recognize that the Intergovernmental Panel on Climate Change has indicated clearly that the impacts of accelerating global warming have disproportionate impacts on the most vulnerable, increasing inequities, particularly for women in the developing world. They call on Canada, that has currently been putting less than, approximately a third of our climate finance has been in investment projects for adaptation, and very specifically missing some opportunities to allocate money as grants instead of loans. The petitioners call for the Government of Canada to commit at least 50% of Canada's public climate finance for developing countries towards adaptation, and at least 15% towards projects that target gender equality as a primary objective. Thank you, Mr. Speaker.
Presenting petitions, the honourable member for Nanaimo Ladysmith.
Well, thank you, Mr. Speaker. It's an honour and privilege to stand today to present a petition by seniors advocates in my riding of Nanaimo Ladysmith. COVID-19 has exposed the degradation of care to seniors and the instability of the workforce. And the petitioners are calling upon the government to include long-term care in public health system by creating national standards for care and staffing levels under the Canada Health Act and ensure accountability. eliminate profit-making by government-funded long-term care facilities, and ensure funds are spent as allocated, and ban subcontracting. Standardize equitable and living wages and benefits, and implement single-site employment for all staff. Strengthen government oversight and initiate strong penalties and clawbacks for facilities not complying with the regulations, and require independent family councils that protect rights. And I'd like to thank Penny McCourt in my riding, and there's 2,500 signatures on this petition. Thank you.
Before proceeding, I just want to remind all the members, when presenting petitions, we ask that you be as brief as possible and have a synopsis. We only have limited time, and we want to make sure that everyone gets to present their petitions. Thank you. Questions on the order paper? Orders of the day.
L'ordre du jour, adresse en réponse au discours du trône.
Address and reply to the speech from the throne.
We have a point of order. Can I come? Okay. Can I come to you as soon as I'm done, and then I'll be right back with you. Thank you. I wish to inform the House that because of the ministerial statement, the government orders will be extended by 20 minutes today. The honourable member for...
Well, there's a lot of petitions there. We're going to set up a video and everything to let people know how about to go with these petitions, where they're at, and all this forward. Well, leave your comments below. Like, subscribe. Have a good day, and stay tuned for question period. It's coming up. It's going to be a big one, no doubt.